The Subcommittee on Environment and Climate Change will now come to order. I recognize myself for 5 minutes for the purposes of an opening statement. Today's legislative hearing will examine H.R. 1603, the Alan Reinstein Ban Asbestos Now Act of 2019. And I would like to start by recognizing Linda Reinstein, Alan's widow, and their daughter Emily, who are with us today. Thank you for joining us, and our heartfelt thanks for being able to carry forward in a really constructive way to respond to a really difficult time for you. I've worked with Linda for a number of years on chemical safety efforts. She is a tireless champion for countless Americans suffering from asbestos-related diseases and fighting for a TSCA program that actually works to protect people from toxic risks. Linda's a powerful voice for the millions of Americans who get up every morning and go to work and raise their families, who have done everything right but who are now facing the painful consequences of some ill-fated toxic exposure they may not even understand, and from a federal government that has, for far too long, failed to take these risks seriously enough. As a result, today, asbestos can be found in countless consumer products, despite our knowing for decades that it is indeed harmful to human health. The dangers of asbestos are not new to anyone. We know the carcinogenic effects of exposure and that asbestos-related diseases kill tens of thousands of Americans each year. I'm so proud to be holding this hearing today, and I hope we're able to move forward on behalf of all the people, the victims and their families that Linda is here to help represent. I look forward to hearing from her on today's second panel along with our other witnesses. The Alan Reinstein Ban Asbestos Now Act was introduced by Congresswoman Bonamici, Congresswoman Slotkin, and Chairman Pallone earlier this year. The subcommittee thanks them for their urgent and timely work. This legislation would prohibit the manufacture, the processing, and distribution of asbestos and asbestos-containing mixtures and articles 1 year after its enactment. It allows for a limited exemption for national security purposes and requires a report to Congress on legacy uses, for example, asbestos already in buildings. In March, this subcommittee heard from workers representing firefighters, teachers, auto workers, and others who have seen the consequences of long-term health impacts of workplace exposure. More than 60 countries have moved forward with asbestos bans to date. For the sake of our consumers and our loved ones, the United States must do the same. In fact, we have tried to do so in the past. 30 years ago, EPA attempted such a ban, which was overturned by the courts in 1991. It was the most glaring example of the inadequacy of our nation's Toxic Substances Control Act, and one of the reasons Congress advanced the Lautenberg Act to reform TSCA. My Republican counterpart, Mr. Shimkus, was the leader on that effort, and to his credit, worked to find compromise and give EPA the authorities necessary to protect Americans from toxic threats. Based on the available public health and scientific data and the heartbreaking experience of Linda's family and hundreds of thousands of others like her, that means stopping asbestos use once and for all. This morning, I suspect we will hear that EPA already has a process underway. Asbestos was selected as one of the first 10 chemicals for consideration under the Lautenberg Act, and the agency recently issued an NUR requiring notification if previous uses are reintroduced into commerce. Unfortunately, that is not good enough. I'm sure other members will discuss concerns with the asbestos risk evaluation. But between that and the agency's treatment of methylene chloride, I have little confidence that EPA will move forward on a reasonable timeline with the only acceptable outcome, a complete asbestos ban. We are approaching 3 years since the enactment of the Lautenberg Act, and it is likely a ban, if proposed at all, will take many years to finalize. Congress came together to give EPA additional authorities precisely so that substances such as asbestos that are nearly universally agreed to present an unreasonable risk could be properly regulated. The bill's supporters are right to think that if this is the direction of EPA claims to be heading, we can ensure a ban moves forward with confidence on a certain timeline. I hope that our members on both sides of the aisle will consider how we might be able to come together, build upon the bipartisan success of the Lautenberg Act, and help protect Americans from preventable asbestos-related diseases. Thank you again, and to Assistant Administrator Dunn and our other witnesses for being here this morning. I look forward to the discussion, and I will now recognize and share my remaining time with Representative McNerney of California.
I thank the chair for giving me a minute here. What I'd like to do is recognize a member of the audience here. Lena Cabadeo, would you please stand? Lena is a Tuesday's child, and she'll be shadowing me today, and I just want to make sure she has a great experience here on the Hill. Thank you for coming, Lena.
The gentleman yields back. I yield back, and the chair now recognizes Mr. Shimkus, our leading Republican for the Subcommittee on Environment and Climate Change, for 5 minutes for his opening statement. Representative?
Thank you, Mr. Chairman. And Mr. McNerney, you're such a nice guy, so... The issue of asbestos use in America and its impact on lung cancer, other illnesses, deaths, is one of the more challenging and gut-wrenching I have found in my time in Congress. I have the privilege to represent part of Madison County, Illinois, and that's my home county. So I know a thing or two about asbestos and the disease it causes. In 2014, 1,500 asbestos lawsuits were filed in Madison County, or more than a quarter of all asbestos cases filed nationally. When I've gone door to door to visit my constituents, I see them in their oxygen machines laboring to live, and I'm aware of the struggle, and it is real. Preventing asbestos-related disease is one of the main reasons I and others came together to enact reforms to the Toxic Substances Control Act. This law directed EPA using high-quality science to identify high-risk chemicals and prioritize them, review those chemicals and the risk, otherwise known as a moment where hazard and exposure intersect, and regulate the ones that present an unreasonable risk to health or the environment. I felt good that we had enacted a process that was objective and risk and science-based, that was drafted to be agnostic as to who was implementing it, and the EPA would have little trouble using very broad authority to carry out the requirements. We didn't single out any chemical by name in that bill, including the use of the word asbestos, but we were all conscious of ensuring that EPA could act on it. And as I and others expected, EPA is doing just that. For the first time ever, preventing lapsed asbestos uses from coming back into the market and reassessing current uses concerning their unreasonable risk and preparing to take any necessary action to reduce and remove those risks. I know, Mr. Chairman, that moving the TSCA bill was a tough process, which you were involved with, but and had concerns with the preemptive provisions. But this is precisely what the majority of both Democrats and Republicans on this committee supported on the House floor. I guess I'm trying to say that I'm a bit frustrated as to why we're having a legislative hearing on banning asbestos before we have had an oversight hearing to demonstrate that the EPA is failing on their technical aspects of the law in its review, missing deadlines, or some other such failing. I know my friend and full committee chairman, Chairman Frank Pallone, has on more than one occasion proclaimed he does not have faith in the professionals at EPA to carry out high-quality review and act the way he would prefer on asbestos. I would respond in two ways. First, under TSCA, EPA has a legal duty to support any decision on existing uses of asbestos with substantial evidence based on objective scientific review. So EPA cannot go into a chemical review with a predetermined outcome if it wants to avoid litigation. Let me say that again, because EPA cannot go into a chemical review with a predetermined outcome if it wants to avoid litigation. Second, let's be honest here, if there were a Democrat in the White House right now, my Democrat colleagues would be very critical of me trying to overturn one of the first existing chemical reviews less than 3 years after its enactment. That is why I have sympathy for at least letting EPA do its work before legislatively rejecting it. I understand the proponents want certainty on this issue. I'm also sympathetic to those concerns. Because of the nature of this place, and unlike EPA, we are much less likely to have the time to consider or otherwise be able to know all the impacts a ban would have directly or indirectly on all Americans, particularly without the benefit of an oversight hearing. Multiple Super Bowl champion coach Bill Belichick preaches to his players, trust the process when preparing for challenges of a season. This formula has been successful for him, and I do believe it would be successful in TSCA. There may be a need to move a bill to address the manufacturing, import, processing, and commercial distribution of asbestos, But before learning more, though, I am not convinced that that time is now. I join the chairman in welcoming our witnesses today. I want to thank them for their sacrifice they made to be here with us, and I look forward to learning more from you all. And with that, Mr. Chairman, I yield back my time.
The gentleman yields back. The chair now recognizes Mr. Pallone, chairman of the full committee, for 5 minutes for his opening statement. Chairman?
Thank you, Chairman Tonka. It's been 40 years since the Environmental Protection Agency began its work to ban asbestos under the Toxic Substances Control Act, or TSCA. It's been 30 years since EPA finalized that ban, and it's been 28 years since that ban was struck down in court. 28 years of frustration, of sickness, and loss. We've known the dangers of asbestos for decades, and frankly, enough is enough. I wish today's hearing wasn't necessary, that this bill wasn't necessary, but asbestos is still being imported into the United States, and it's still being used in this country, and it's still killing about 40,000 Americans every year. Today, this committee is beginning to take action by discussing H.R. 1603, the Alan Reinstein Ban Asbestos Now Act, which Representatives Bonamici, Slotkin, and I introduced in March. Our bill would ban the manufacture, import, processing, and distribution of asbestos. It would also require the EPA to assess and report on the risks posed by legacy asbestos that is found in buildings. In addition to Representatives Bonamici and Slotkin, I want to thank some of those who've worked tirelessly to get us to this point. Linda Reinstein, whose husband Alan is the bill's namesake, will testify this morning. Linda, thank you for everything you've done and everything that I know you will continue to do to get asbestos out of commerce, out of our products, out of our workplaces, out of our homes. I'd also like to thank national and local labor unions who have been fighting for decades to protect workers from asbestos diseases. AFL-CIO is also here today. In March, we heard from the International Association of Firefighters, the United Auto Workers, and the American Federation of Teachers, who all testified before this committee about the risks that workers continue to face from asbestos. Those stories and those people at risk are why we're here today. Also want to acknowledge Susan Moran, who is in the audience today. Susan's late husband, Andy, pronounced egregious, was an integral part of this committee's work to reform TSCA. And finally, I'd like to thank the subcommittee ranking member, Mr. Shimkus, who worked closely with me and Chairman Tonko and other committee members to reform TSCA back in 2016. It was not an easy task. The Frank R. Lautenberg Chemical Safety Act for the 21st century, that's TSCA, empowered EPA to ban asbestos. In fact, this committee's report on the Lautenberg Act, written under Republican leadership, states, and I'm now quoting, "To many members of the committee, an important measure of TSCA reform proposals has been whether the proposal would enable EPA to take broader regulatory action to protect against unreasonable risks from asbestos. The committee expects this legislation to enable that regulatory action." And that was from the committee's report on our expectations. But unfortunately, it's now clear that despite the best efforts of our committee, the Trump EPA is not using the tools we gave it to regulate dangerous chemicals. Asbestos is the poster child for the problems we're seeing in the implementation of the Lautenberg Act. EPA's actions under the Lautenberg Act have been so legally suspect that I believe we need to pass this bill regardless of whether EPA were to announce that it's moving forward with a full ban of asbestos. We don't have time for more legal maneuvering and a drawn-out court battle while tens of thousands of people are dying. So it's deeply disappointing that 40 years after EPA began work to ban asbestos under TSCA, and 3 years after we passed the Lautenberg Act to reform that statute, we need to pass another law to ban this deadly substance. But I think it's clear that Congress must act, and we're certainly going to act. So with that, unless anybody else wants my minute, I will yield back. And thank you, Mr. Chairman.
You're welcome. The gentleman yields back. The chair now recognizes Mr. Walden, the Republican leader of the full committee, for 5 minutes for his opening statement. Representative?
Good morning, Mr. Chairman, and thank you. As we examine the bill today from Mrs. Bonamici and others, I must say I'm actually of several minds, and let me explain. At a 50,000-foot level, I join my colleagues in wanting to see an end to mesothelioma, cancer, and other pulmonary diseases precipitated by asbestos. I think we all want that. To the family suffering and those with these diseases right now and those who have lost loved ones to them, I'm deeply sympathetic to you and obviously for the advocates of this bill. I recognize the tragedies you have faced, and I understand you want a solution once and for all. I also appreciate the way my colleague, Mr. Shimkus, has said about the process he authored a few years ago to modernize the law to address questions of safety about chemicals. I think these have to be fact-based decisions. And as we speak, and that Mrs. Dunn will talk about on the first panel today, if Congress is going to consistently, though, preempt the sort of science-based EPA reviews with statutory mandates, one has to ask the question, then, what's the point of all these newly expanded authorities under TSCA? Even well-meaning legislation can, frankly, be a bit of a blunt instrument for problem-solving where, if not careful, Congress can create risk trade-offs that spawn unintended public health risks, institute unimplementable enforcement requirements, or require complex and hard-to-meet compliance obligations. So as I went through and looked at this legislation, a number of questions came to mind. This legislation requires any mixture or article that is distributed in commerce to not have asbestos present as an impurity. So my question is, does this apply to incidental fibers? Do American businesses have to test and certify every product sold in this country to guarantee it does not contain any asbestos, regardless of whether it was intentionally added? Do people in rural areas no longer get to use gravel for roads? Should talcum powder fall under this, or would it be exempted as an FDA-regulated product? These are just some of the questions that come to mind. The legislation also requires very specific and complex reporting to the EPA by those who either manufactured, imported, processed, or moved in commerce asbestos or mixtures or articles containing asbestos, including an incidental amount, in the 3 years prior to and 1 year after the bill's enactment. So prior to and 1 year after. So how does a person report an incidental amount when they weren't expected to track it? What's the utility of all this reporting to EPA on top of information from EPA's chemical data reporting, especially if the substance is already banned? Why is personally identifying information disclosed to the public? We're doing a lot on privacy in this committee. So the question, why is personally identifying information disclosed to the public from each report when EPA is only required to produce an aggregated report that isn't specific to each person reporting? Finally, the legislation provides a shorter transition period and moots existing TSCA provisions preempting an exemption for use of a chemical that provides greater public health protection than its alternatives, which I think is a pretty important point. I'm especially concerned about the immediate loss of 36%, that's over 1/3 of our nation's chlorine production, and what that means for hospital disinfection, drinking water treatment, pharmaceutical production, and the like. The resources required could push businesses to import materials rather than make them here. And do healthcare costs and drinking water rates spike? Does availability of these services lessen, or do gaseous chlorine shipments come to our major ports? So to protect the economic health of working men and women, are alternatives technologically and economically feasible? I think that's a question we need to look at. And if so, are they drop-in ready and safer? So, Mr. Chairman, while I support the intent, certainly, of my colleague from Oregon, Ms. Bonamici, and others, I do think there are these questions among a whole list that if we're going to legislate in this space, we need to get answers to if we're going to be responsible. So I look forward to hearing from each of our witnesses today. I know their testimony will better clarify some of these for me, and I appreciate that. I would also say at the outset we have 2 subcommittees meeting simultaneously, and since I'm on both, I'll be coming and going. But I do have your written testimony, and again, we all want to make the world safer, and for those who are suffering or who have lost someone, you are in our hearts, and we want to do the right thing here. So with that, Mr. Chairman, I yield back.
The gentleman yields back. The chair would like to remind members that pursuant to committee rules, all members' written opening statements shall be made part of the record. I now introduce our witness for today's first panel, Alexandra Dunn, the Assistant Administrator of the United States Environmental Protection Agency, Office of Chemical Safety and Pollution Prevention. Before we begin, I would like to explain the lighting system. In front of you are a series of lights. The light will initially be green at the start of your opening statement. That light will turn yellow when you have 1 minute left. And please begin to wrap up your testimony at that point. The light will turn red when your time expires. So we thank you for that help, Administrator. At this time, the Chair will recognize Assistant Administrator Dunn for 5 minutes to provide her opening statement.
There are no lights on her table.
Oh, there's no lights on your table, okay. So, forgive me, all that.
Wait.
Okay. Thank you. Miracles of all kinds. So, Administrator, 5 minutes, please.
Well, good morning, Chairman Tonko, and notwithstanding the absence of the lights, I can see the clock up there.
Okay.
Chairman Pallone, Ranking Member Shimkus, and Ranking Member Walden, members of the committee. As you heard, I'm Alexandra Dunn, Assistant Administrator of EPA's Office of Chemical Safety and Pollution Prevention, and it is a great privilege and honor to appear before you today to discuss asbestos. I am pleased to share with you the significant efforts EPA is undertaking to address public health risks from exposure to asbestos. This administration is the first in 30 years to use the Toxic Substances Control Act, amended by the Frank R. Lautenberg Chemical Safety for the 21st Century Act, to place additional restrictions on products that contain asbestos. It's helpful to look at EPA's asbestos regulation in 3 phases. As you noted, EPA's actions around asbestos took a major step forward when, in 1989, we finalized the TSCA asbestos ban and phase-out, banning the manufacture, importation, processing, and distribution in commerce of most uses of asbestos. In 1991, this regulation was largely overturned by the Fifth Circuit, leaving only 5 asbestos products and all new uses of asbestos banned. The 1989 partial ban remains in place, and our new actions build upon it. Second, on April 17, 2019, EPA closed a loophole left by the 1991 court decision. We signed a regulation that will prevent historic uses of asbestos from returning to the U.S. through domestic manufacture or import without EPA review. Our action affects 18 categories of historic asbestos-containing products, such as asbestos vinyl floor tiles and insulation, and has a catch-all restricting any other uses of asbestos not currently ongoing. This is an aggressive and critical step to protect the public from the health risks associated with asbestos, including the increased risk of cancer. Third, we complete the circle of protecting the public from asbestos risks as we undertake a risk evaluation for the limited ongoing industrial uses of asbestos. A TSCA risk evaluation, as described by Mr. Shimkus, determines whether a chemical substance presents an unreasonable risk under the conditions of use to health or the environment, including an unreasonable risk to relevantly potentially exposed or susceptible subpopulations, such as workers. If EPA determines that the manufacture, processing, distribution, use, or disposal of a chemical substance presents an unreasonable risk, we must take risk management actions under TSCA Section 6. Our process is open and transparent. The asbestos draft risk evaluation will be peer-reviewed and available for public comment under the timetables in TSCA. We received 2 petitions asking EPA to require additional asbestos reporting. After consideration, EPA denied both petitions. Through preparing the asbestos scoping document and drafting the risk evaluation, we are confident that we have a sufficient understanding of the conditions of use of asbestos. We understand that many stakeholders want EPA to ban all remaining asbestos products now. Under TSCA, EPA cannot move directly to risk management actions such as a ban without first completing the risk evaluation and making an unreasonable risk determination. This is the path we are following, consistent with our legal authority. EPA has also received comments asking us to address risks from legacy asbestos, asbestos-containing materials manufactured or imported in the past that may still be present in buildings and homes. We are not ignoring the legacy problem. Asbestos-containing materials that are not damaged or disturbed are not likely to pose a health risk. When asbestos is to be disturbed, federal, state, and local laws, regulations, and programs are in place for the safe removal and disposal of these materials. The outlined actions show that we are committed to protecting all Americans from unreasonable risks associated with asbestos and to working with stakeholders and our federal, state, and local partners. Again, for the first time in decades, EPA has made addressing asbestos a priority. On March 7th, 2019, Representative Bonamici and others introduced H.R. 1603, the Alan Reinstein Ban Asbestos Now Act of 2019. EPA does not have a formal position on the bill, but can provide technical assistance on this issue upon request. In conclusion, thank you, Chairman Tonko, Chairman Pallone, Ranking Member Shimkus, and Ranking Member Walden, and members of the committee for the opportunity to testify before you today. EPA looks forward to continuing our work with you to protect the public's health and well-being, and I look forward to any questions.
Thank you very much. Now that the Administrator has concluded her opening statement, we'll move to member questions. Each member will have 5 minutes to ask questions of our witness. I'll start by recognizing myself for 5 minutes. Administrator Dunn, thank you again for appearing before the subcommittee. It's my sincere hope that you're able to lead the Office of Chemical Safety and Pollution Prevention effectively. In my opinion, the office went off track in the early years of the Trump administration. Congress passed the Lautenberg Act to have certainty that EPA would have the authority to ban indisputably harmful substances like asbestos. 3 years later, and I certainly am not as confident that will be the ultimate outcome. Administrator, do you have any thoughts on how over 60 other nations, and even the U.S. at one time when it had banned asbestos, have managed to continue to be productive despite having banned asbestos?
We are always engaged in international conversations with other countries. We believe that we are implementing TSCA, the new law that we have, using all of its authorities and powers that we have to look at asbestos, and feel very confident that we have the tools that we need.
And do you have concerns that the United States could not manage that transition?
I am confident that we are able to manage the transition to the new Lautenberg law. We have met all the deadlines under the new law to date.
Well, with the ban in general, could we manage that transition?
Managing a ban, if under TSCA we reach a conclusion that there is an unreasonable risk presented under the conditions of use and that a ban is the only way that those risks could be mitigated, EPA would have the capability to manage that process.
And obviously work has been done going back to the 1970s on the U.S. ban. There are career staff at EPA that have been working on asbestos for literally decades. What role do you believe EPA career staff should play in determining the agency's path forward on asbestos?
I'm absolutely privileged every day to work with our career staff. They have prepared me today for speaking with all of you. They have incredible expertise about asbestos, how it's used in the United States. They did all the groundwork around our risk evaluation, and they are absolutely dedicated to the task at hand. Very committed to the public service.
In late August, the New York Times reported a story entitled, "EPA Staff Objected to Agency's New Rules on Asbestos Use, Internal Emails Show," which outlined career staff's concerns with the SNUR proposal. I appreciate that story was published before your confirmation, but just this morning the Times published EPA leaders disregarded agency's experts in issuing asbestos rule memos show. Do you have any thoughts on these stories or understand why it may cause some members to question EPA's political leadership's commitment to implementing a ban?
I don't want to comment on internal conversations amongst our staff. We encourage full disclosure and conversation amongst our teams. We explore a variety of options at all times, and my door remains open to any member of our staff who feels they are not being heard with regard to their professional opinions.
But moving forward, do you plan on seeking input from career staff from across program offices on asbestos and other risk evaluations?
Absolutely.
And I know you previously led EPA Region 1. Do you believe the career staff at regional offices can provide valuable insights?
Having been the regional administrator in New England for all of 2018, I have a great appreciation for the ability of our EPA regions, many of whom you all interact with when you're home. That's the EPA that you see, not necessarily the Beltway EPA. What I really enjoyed about the regional office is that we were very close to communities. I went to many public meetings. I sat with communities, probably got a flavor for what you all go through when you go home, when you listen to communities with concerns. whether it was with regard to Superfund sites or other chemical exposures. So being on the ground, to answer your question, yes, our regions can be very helpful to us with that direct communication from the field, essentially.
And are you familiar with criticisms by Region 10 staff of both the proposed SNR and the scope of the risk evaluation from May and August 2018, respectively?
I'm not familiar with the Region 10 staff.
Well, based on some of these communications, it seems clear that numerous EPA career staff believe the agency is not fully pursuing efforts to reduce asbestos exposure. And I hope these expert voices have an appropriate role in the process as it moves forward. And with that, I thank you for your response to our questions. The chair now recognizes Mr. Shimkus, our leading Republican on the subcommittee, for 5 minutes to ask questions.
Thank you, Mr. Chairman. I get the sense in listening to the majority that they're concerned that comprehensive action on asbestos isn't happening and they want it to occur immediately. I detected from your opening statement that there is an effort within EPA's TSCA work to get at many of these things. So can you help me piece together how the agency is addressing asbestos? Can you please walk me through the thinking and implications of EPA actions on your significant new use rule on asbestos and the ongoing risk evaluation of asbestos?
Yes, it would be my pleasure to do that. The significant new use rule, which we just signed a few weeks ago, is a very important action for us to take. It makes clear that any historic, not ongoing use of asbestos cannot occur and resume in the U.S. without notification to EPA. Notification to EPA provides us all the tools in TSCA to look at the proposed use. If anyone thought that getting into the business of asbestos was a good idea, they would have to come forward to the EPA. We would have to look at the type of activity that they wanted to undertake. We would have to assess any potential risks, and we would have to put requirements on that activity to mitigate all risks. The requirement could also turn out to be a no, that they may not commence that activity. So the action we took with the SNR is very important. It puts EPA in a very important place with regard to these historic uses.
Thank you. Are you on track to timely complete your evaluation and make a determination on asbestos by the end of this year?
We are on track. We are completing the risk evaluations of asbestos and the other 9 chemicals. Just this morning, an announcement went out that our Science Review Committee, which is brand new under TSCA, will be meeting in June to begin looking at the first 10 chemicals, and we will be moving our way through them throughout the summer. We are very much anticipating meeting our end-of-year deadlines.
That's that purple 29 one.
Pigment violet 29.
Purple was my high school color, so some of you heard today, what you've heard today, and the dinging the agency for not addressing legacy uses of asbestos. What do you say in response to those criticisms?
EPA's authority under TSCA has to do with the manufacture, distributing, importation, and use and disposal of asbestos. So we are focusing on our legal authorities. When it comes to legacy uses, EPA relies on the fact that there are many, many other programs, including under OSHA, under our Clean Air Act, the NESHAP. There are requirements for anyone who is to disturb asbestos when it is intact. We want to make sure that that is done safely and properly. So there are many controls at the state and federal level around legacy asbestos.
In 2016, EPA designated asbestos as one of the first 10 chemical substances subject to risk evaluation. Is the agency on track to complete this risk evaluation by the end of 2019?
We do remain on track, yes.
Can we expect a determination regarding unreasonable risk for all the conditions of use the agency identified in its scoping document from June 2017?
I cannot prejudge today what we will find through our risk evaluation. The risk evaluation will go to peer review, also to public comment. We are looking at the limited ongoing uses of asbestos. Right now, they are industrial. They largely have to do with the fabrication of diaphragms for chlorine and sodium hydroxide production, as well as some other very, very narrow industrial uses.
since HR 1603 is silent on it, what legal effect does HR 1603, if enacted, have on ongoing risk evaluation and any resultant risk management requirements?
The fact that the bill is silent on that is of some concern. It does not tell us to stop our work, and so we would hope to reach some clarity around that should the bill advance.
Thank you. My time's expiring. I'll only just say those are questions I wanted to get on the record. I tell people I hate asbestos, okay? And but in delving down into chemicals and dealing with the risk issue, I like the fact that chlorine is a major use in keeping water safe for use. I like the soda hydroxide for cleaning hospitals. So we have some issues here, but I appreciate you being here. I'm sorry to go over time, and I yield back.
Gentleman yields it back. The chair now recognizes the gentleman from California, Representative Peters, for 5 minutes.
Thank you, Mr. Dunn, for being with us today. Can you explain to me what has been the status? Well, let me ask first. What's been the status since between 1991 and up to the time of your issuance of a SNR, significant use rule, on asbestos? How's that differed from what you're doing now?
There was not a significant movement to bring historic uses back to the United States. However, we took action on the SNR to ensure that that could not occur.
Okay. And so have you been approached by people who want to continue to use asbestos or to use it in ways that would require the development of a significant new use rule? Is that what?
We have not been approached right now by entities that intend to commence these asbestos uses.
Okay. So what would be examples of asbestos-containing goods that you'd expect would be eligible for the case-by-case approval?
Some of the historic uses that we address in the SNR are 18 categories. They include building insulation, asbestos, vinyl, floor tile, roofing tiles. Those are some of the examples of products that historically contained asbestos that are not currently being imported or brought into the United States, and we would want to ensure that before that ever occurred, EPA would have a chance to review that.
And it's my understanding that in each of those uses, substitutes have developed for asbestos that have been effective. Is that your understanding as well?
I'm not aware of the full range of substitutes, but I know that roofing is occurring today without imported asbestos roofing tile.
Right. How would your evaluation of a significant new use rule application be affected by the availability of substitutes in the economy?
Well, certainly through our chemicals program, we are always looking for new chemicals. We have an entire new chemicals program where innovators bring forward new chemistries. They ask us to review them. That's another one of our authorities under TSCA. We review new chemicals. We determine if any restrictions need to be placed on them. We don't say that every new chemical is air quote greener than an existing chemical, but in many cases, the new chemistries coming forward are shorter lived in the environment, more focused in how they act in the environment, and can, in some cases, be greener.
Let me be a little bit more focused. So let's take building insulation, which has been the big use over time and from which a lot of the friable asbestos has come. That's not the standard anymore. People are using different materials for building fire retardants and for insulation. Those are available in the economy, and then someone comes to you, they want to do a new product for that use with asbestos in it. You have to evaluate the risk, right? And so is part of the evaluation of the risk for the new product the fact that it's really not needed because the need for it has been met by other substitute products?
We look at a full range of factors under the law as to whether or not that product can come to market. Most of our review is around the safety of the product. We do look to see if there are other products in the marketplace that can give us a sense of risks, but EPA is not in the role of making decisions about the marketplace.
Okay. Can you describe for me what the analysis is generally behind a significant new use SNR application?
Right, so as an application comes in, we have a team of risk assessors, risk evaluators. We have
Health risk assessors, health
health
risk
risk
evaluators.
assessors, yes. Exposure experts. They look at all the conditions of use. They not only look at what that applicant says they want to do with that chemical, but they also have to, under TSCA, look at other reasonably foreseeable uses.
Right.
So we have to look out and determine if there are any other uses that maybe the applicant has no intent of using the chemistry in that fashion, but we look at the other ways it could be used. We assess any of those risks as well. Then we come back and we determine if there are requirements that need to be put in place to mitigate risk.
And how do you determine what an acceptable level of health risk is? given the
Well,
exposure?
it depends on the chemical, but we look at the hierarchy of controls. So we look at how are largely the workers coming into contact with the chemistry. So we look at ventilation, we look at how.
I'm sorry, I've got 3 seconds left. Let me just tell you my concern. We can take
Okay.
it up later, which is that you could decide that you're willing to take a certain amount of risk if it's a product that's necessary to meet some need in the economy. What I'd like to hear is that, given that there's other ways to meet that need in the economy, you would take a hard line on asbestos in evaluating what risk is acceptable. And I yield back.
The gentleman yields back. The chair now recognizes the representative from West Virginia, Representative McKinley, for 5 minutes. Representative.
Thank you, Mr. Chairman. In the construction industry, we have found ways of dealing with asbestos over the years, and we've banned the product quite effectively, finding alternative materials, even though polyurethane is then often criticized because it has other environmental issues in using polyurethane. So in the construction industry, we've found ways of dealing with it. But after this, the 89 ban and then the 91 being overturned, from what I understand, that only 5 products apparently were ultimately completely banned, and that allowed us people to continue using some form of asbestos. So I'm curious, since the construction industry came up with alternatives that were viable, effective, why hasn't the industry been able to replace asbestos to be used in all other products? Why in God's name do we still use this thing?
Well, we largely do not use it. So the action that we took a few weeks ago is to ensure that any of those historic uses that were left out after the court decision invalidated our total ban. What we did was we took the 18 categories of uses that were still available should someone decide to enter the U.S. marketplace with them. No one has been. They are dormant uses. But what we have done now is close the door to ensure that someone could not decide to bring back one of those uses for whatever reason they chose without coming through EPA.
Can you explain a little bit about the chlorine? I need to understand that because we've banned all the piping with it. How is that involved with chlorine?
So
These
EPA,
chlorine filters, I think you said something of filters.
EPA is required under TSCA to look at the ongoing conditions of use of asbestos. So you were asking, where is asbestos still used in the United States? Not largely in building and construction, as you mentioned.
Know that.
But I will tell you where it is used. It is used in all through import. All the asbestos that comes into the United States today is imported from other countries. And the imported raw bulk asbestos is used to make diaphragms for chlorine and sodium hydroxide production. It's also used in sheet gaskets in chemical production, such as titanium dioxide production. It's used in brake blocks in oil drilling equipment.
So, okay,
Yeah.
I can read that as well, but why do we allow that? Why are we allowing imports to come in that are hazardous?
So this is the risk evaluation process that EPA is undertaking now. We are looking at all those uses and a few more that I just listed. We are looking at whether these uses pose unreasonable risk. And if we find that they pose unreasonable risk, We have 2 years to take
Well, aren't they an
regulatory
unreasonable
action.
risk? If we don't allow our American manufacturers to do it, why would we let a foreign manufacturer do it?
Well, these are American companies importing these, this raw asbestos for these limited industrial uses.
Well, you've opened up a can of worms here with that. So let me just say, maybe following back up again with Shimkus was raising on his questioning, and I've got just a minute left on it. Can you follow up more on the importance of following the procedures outlined under TSCA when considering future actions? I'd like to understand more of that aspect of it.
Well, what I hear from you, Representative, is a great concern about these remaining uses of asbestos. And so the process that we are following is that by the end of this year, we will complete a risk evaluation of any risk that we identify under these uses in the chlorine manufacturing and the other industrial uses. We then, if we find unreasonable risk, and we have to make that finding under TSCA, if we find any unreasonable risk, and it wouldn't be across the whole category, we have to look at each use, then we have 2 years to take a risk management activity. That could require labeling, restrictions, a whole variety of ways to get rid of that risk. The most significant way to get rid of a risk is a ban, but that's only one of our tools.
Okay, I guess I've run out of time on it. I'm just, what you're explaining to me is, I understand this, I'm walking out of this now. You said American manufacturers can't make the asbestos product, a brake block, a brake assembly, but if they go overseas and import it, they can.
They're bringing the asbestos in.
That's incredible. Thank you. I yield back.
The gentleman yields back. We now go to the voice of Delaware, Representative Blunt Rochester.
Thank you, Mr. Chairman, and thank you, Ms. Dunn, for your testimony. Based on the scientific evidence available at the time, EPA determined in 1989 that a ban on asbestos was necessary to protect human health. That decision was based on 10 years of work and an exhaustive record. In the 30 years since the ban was published, research has shown more dangerous forms of asbestos and more deadly impacts. We now know that asbestos not only causes mesothelioma and lung cancer, but also cancer of the larynx, stomach, and colorectum, and ovary. Unfortunately, EPA excluded those cancers from the problem formulation document for asbestos. Ms. Dunn, can you explain why EPA excluded those cancers from the problem formulation document?
Well, we are looking at the industrial uses that I was just explaining, those 5 or 6 limited industrial uses, and we will look at any health risks associated with those uses. So if there are health risks along the lines that you identify, we will be looking at all the relevant literature.
I actually have a document to submit for the record, and it's a memorandum prepared by career staff in EPA's Region 10 office, raising concerns about the EPA's problem formulation for asbestos, and I'd like to submit this for the record.
Mr. Chairman, I reluctantly object to submission. As the assistant administrator spoke earlier, she can't comment on internal documents, so for us to having an open hearing here without her ability to comment or put the whole memo in context, I wish we wouldn't ask for that to be submitted.
Mr. Shimkus, I believe our colleague wants simply to relate what she has before her and ask for a response from the witness. And I believe if she puts it in a context, if she shares the statement, all we're looking for is a reaction to that statement.
And Mr. Chairman, could I just briefly read a quote and then respond to the quote?
Well, I can't stop you from reading a quote. My concern is a submission for the record, and this not being the Oversight and Investigation Committee. But I want to also say, Chairman, if I may, and if your time, can I? I'm open to have a debate on these memos in a bipartisan process somewhere outside of this hearing.
Well, then I say fine, let the representative go forward with her quote.
Okay. So this is the quote. There are other significant lethal and non-lethal harms from asbestos exposures, including asbestosis and other respiratory ailments, ovarian cancer, colorectal cancer, and cancers of the stomach, esophagus, larynx, and pharynx. These additional harms should be included if there is to be a comprehensive evaluation of the risks from exposure to asbestos, end quote. And so the question was, do you dispute that claim?
Well, Representative, I am not familiar with that, and I prefer not to comment on internal deliberative conversations of our staff.
What I thought I did hear you say earlier is, because my next question was, would you consider these cancers in the risk evaluation? And I think I heard you say,
If our evaluation of the conditions of use reveal that those types of cancers are a possible outgrowth of the ongoing conditions of use, then we would not rule them out.
okay. So, Assistant Administrator Dunn, we always talk on this committee about risk as a product of hazard and exposure. And do you agree with that as part of the formulation?
That is absolutely how we approach risk at the U.S. EPA.
So I have 1 minute. To me, it seems obvious that excluding those hazards and those exposures undermines the validity of your risk evaluation and amounts to considering non-risk factors, which is prohibited under TSCA. That is why I share the chairman's concerns that your actions under TSCA on asbestos will not survive a court challenge. That's one of the concerns, and why I don't think we can really wait to ban this substance. And I support this bill and hope my Republican colleagues will also join me in supporting in doing so. Thank you. I yield back.
Our representative yields back. The chair now recognizes the gentleman from Ohio, Representative Johnson, for 5 minutes.
Thank you, Mr. Chairman. We're discussing a very important issue today. There's no question about that. I share the concerns about asbestos. I don't think there's any question about the health implications of asbestos. However, Assistant Administrator Dunn, I'm trying to piece together how the implementation of the required private sector reporting would work based on this legislation, H.R. 1603. It appears to be silent on how to determine if asbestos is contained in a material or product, in particular those containing asbestos as an impurity. So how would the EPA define impurity for the purposes of implementing this legislation? Could it be one strand of fiber?
Thank you for your question. Currently, TSCA Title II defines an asbestos-containing material as a material containing more than 1% asbestos by weight. That is what we use today. Our review of the bill does not reveal that it includes a factor like that.
Okay. Does it seem reasonable to you that standardized, cost-effective test methods may be necessary to implement the ban?
Yes, absolutely. There are a number of different test methods. There is no sort of consensus method at this point, so it would require some time to agree in the scientific community as to what method would be the best of the many that
that's some of the devil in the details, because when we have no agreed upon standardized tests, then we wind up shooting with a shotgun instead of with a laser to try and solve a problem. Is there a test in particular that could easily be deployed?
In talking to our technical experts, there are a variety of tests. They would want to do more research to respond to your question in terms of how easily some might be deployed over others.
Could you get back to us on that?
Be happy to do that.
Okay, and you might have to give the same answer for these other questions as well. Is there enough expertise and laboratory capacity to operate these tests for compliance purposes?
We have not done an assessment of laboratory capacity at this point.
Okay. Can you get back to me when you do?
We can.
Okay. Do you read H.R. 1603 to assume those persons subject to its ban provision would need to test products and materials to comply?
Our review of the bill does appear to require testing, yes.
Okay, so other than tobacco products, pesticides, guns and bullets, nuclear materials regulated by the Atomic Energy Act, and items regulated by the Federal Food, Drug, and Cosmetic Act, would every other item manufactured, imported, processed, or distributed in commerce be subject to these requirements?
I think at least our initial assessment is that the bill is focused on asbestos, but it could certainly set testing precedent.
But, well, I know it's focused on asbestos, but you don't know until you test. So my question is, other than tobacco products, pesticides, guns and bullets, nuclear materials, and those food items, or those items regulated by the Federal Food, Drug, and Cosmetic Act, seems to me that every other item manufactured, imported, processed, or distributed in commerce would be subject to these testing requirements under the bill. Is that correct?
We have not done a complete assessment of that, but we would be happy to get back to you.
Would you please?
Yes.
Thinking about the utility of all this reporting or on a substance that is being banned, do you see a clear benefit to the agency for using this information that's required to be collected by H.R. 1603?
We believe through our work under TSCA that we have a very good understanding of the limited ongoing uses of asbestos in the United States. So we do not believe that the information requested by this bill would be particularly helpful to the agency. It would be a significant undertaking to gather it.
Okay, kind of a corollary then, since the risk evaluation of asbestos will be over by the end of 2019 and the bill bans asbestos, how might the agency use all this information that it's going to be collecting?
It's unclear exactly how we would be able to use the information given the timelines of our work under meeting the TSCA deadlines.
Okay, all right. Mr. Chairman, I'm going to yield back the balance of my time, a whole 20 seconds.
Well, I think we're a little off with the clock, so it's fine. You didn't lose any seconds. So the gentleman yields back. The chair now recognizes the gentleman from Florida, Representative Soto, for 5 minutes.
Thank you, Chairman. And I think we understand the history of this. Generations of workers who lost their lives due to a chemical that since the 20s here in the United States, there was an awareness of its toxicity. We see these mesothelioma commercials are ubiquitous across TV. People get a sense this is dangerous and it no longer should be in society. So I think one of the biggest surprises to me being new on the committee is how this took so long to even get to this point. A lot of my colleagues like to extol the importance of common sense. It'd be a great time to apply it here. The public expects us to get it right, particularly on public health. They assume we're going to stop things that are going to kill us from being in commerce anymore, and that's one of our biggest, duties here. The Lautenberg Act was a great work, great bipartisan work that set up a great framework. That was then, and this is now. We aren't bound even by this great framework that could help with a lot of other chemicals. As you know, we can, as our prerogative, set up a general process and then still, on this law, get more aggressive with certain chemicals, in this case, asbestos. Being a co-equal branch, we're not bound by agency action or inaction. I guess my first question is asbestos still being manufactured in the United States?
No, all the asbestos in the United States is currently imported.
Okay. So, but it's still being purchased and in commerce at this point?
It is brought into the United States for the limited industrial uses that I've previously alluded to.
Do you know how many new cases of asbestos exposure have happened post the Lautenberg Act?
I do not have that figure available, but I'd be happy to get back to you on that.
Do you have an estimate? Is it in the hundreds? Is it in the thousands of people?
I don't have an estimate of that.
So we don't know how many people are dying still because of inaction. Is that correct?
We do know that some asbestos-related diseases are many years in revealing themselves. So the Lautenberg Act was passed in 2016, and we have been aggressively working on asbestos since then.
But there could be new exposures happening post that we'll find out about 10, 20 years from now, right? Is that fair to say?
Under the risk evaluation that we're conducting of the limited industrial uses that remain, we are looking at exposures, particularly to workers.
Does the EPA oppose having a ban of asbestos?
We have no position on the bill.
Okay. And so what's holding us back? What are the benefits of continuing to have asbestos in commerce currently in the United States?
Well, what we have determined, and again, we are doing a risk evaluation of this process, is that for about the 5 or 6 industrial uses that they import asbestos to the United States for chlor-alkali production, sodium hydroxide production, several other sheet gasket production, that this asbestos is still the product of choice. That is not EPA's role to tell the companies what product to use.
So it's not the role of EPA to tell companies what product to use that we know has a substantial risk of cancer? Is that what you're saying here?
We are following our legal process, and so if we reach the end of our risk evaluation process and find unreasonable risk from the use of asbestos in these industries, we then have the legal power to take a number of important steps, which could include what you're looking for, which is saying that it could not be used any longer.
And how long do you think it's going to take to finish this process?
We have 2 years after the end of this year to complete that process.
And do you expect you'll take the full 2 years?
I don't want to speculate on how long it will take us to act. We will act expeditiously.
Okay. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Missouri, Representative Long, for 5 minutes. Representative.
Thank you, Mr. Chairman, and thank you, Ms. Dunn, for being here. I think that we can all agree that asbestos is one of the few things that has a lower approval rating than members of Congress. So we all are in agreement that whatever we can do to help in the situation, we need to get done. This bill before us today would require entities to report to the Environmental Protection Agency regarding use, quantity, and exposure of asbestos within the last 3 years prior to its passage. The bill would also require the Environmental Protection Agency to make this information public within a certain time frame. Question for you, would the EPA be able to meet the information collection requirements under the Paperwork Reduction Act for deadlines required from H.R. 1603 for producing reporting instructions and forms?
Thank you for your question. The EPA and all federal agencies are always extremely cognizant of the burdens of information collection by the federal government on the American public and on anyone who has to respond to our requests. Our preliminary assessment is that the amount of data collection contemplated by this bill would be quite significant and quite impactful.
Based on how you read this legislation, do you have an estimate of how much it would cost the EPA to implement the information collection requirement?
We have not done an estimate.
You have no estimate at all?
No.
Okay. What would the impact be to EPA's current TSCA budget to implementation? I guess you don't know that either if you don't know what the cost is going to be.
What I can tell you is that our TSCA staff are working dedicatedly to meet the deadlines under TSCA. This law, which as you know was significantly overhauled in 2016, put us on a very aggressive clock to look at a number of chemicals. The first 10, we're already identified 20 more that we're looking at, another 20. What I can say is that requirements like this would certainly put an additional strain on our current staff.
Okay. The public disclosure provisions are an amendment to TSCA Section 6, which are further governed by confidential business information provisions in Section 14, as well as the Federal Trade Secrets Act. This might tie into what you were saying a minute ago, but do you see any conflict at all between the information this bill requires to be released and existing federal law protecting the disclosure of certain types of confidential information?
One of the obligations that we have in the chemical program is to be very respectful of confidential business information. I'd like to note that the confidential business information provisions were the provisions of TSCA completely struck by Congress and completely replaced. So we look at those new provisions very, very carefully. We've not done a full analysis of any potential conflicts between this bill and our existing confidential business information requirements, but we would be happy to get back to your office on that.
When my friend Mr. McKinley was questioning you about the 4 or 5 existing commercial purposes that asbestos are imported into the United States for their usage, did I understand you all are doing a study on that or not? Or
Yes. Yes, we are required under TSCA as since we named asbestos one of the first 10 chemicals, we are doing a full risk evaluation of all of those uses. And at the end of that process, we have to make a determination of unreasonable risk or no risk, essentially. And so if we reach an unreasonable risk determination, we then have 2 years to regulate it, meaning we could require a variety of different controls to take that risk away. There are lots of ways to remove risk. You could produce the chemical in a completely sealed box where none of it gets out. But another option that is open to EPA under the law is a ban. That's another way to remove the risk.
Okay.
But we can't prejudge where we're going to go with that.
And what's your time frame as far as completing this study?
We are on track to complete the risk evaluation by the end of 2019, and then under TSCA, we have 2 years to complete the regulatory action.
By the end of this year,
By the end of 2019,
December 31,
so
2019, your study will
2021,
be.
we would complete the we would complete the risk management component of the remaining limited uses of asbestos.
Okay, thank you. Mr. Chairman, I yield back.
Gentleman yields back. The chair now recognizes the chairman of the full committee, Mr. Pallone, for 5 minutes.
Thank
Chairman?
you. Thank you, Chairman Tonka. Every day, it seems, new evidence comes to light that EPA is failing to protect the American people from asbestos and toxic chemicals in general. On asbestos, everything we've seen out of the agency, from the scoping document to the recent significant new use rule to the denial of a petition by multiple state AGs, shows a desire to discount risk and entertain the possibility of new ones or new uses. So I don't think EPA is moving towards a ban, but Administrator Wheeler did commit when he was here last month to promulgate a ban. So my question to you, Ms. Dunn, are you aware of Administrator Wheeler's commitment to me last month to ban ongoing uses of asbestos under TSCA?
I can't comment on the administrator's representation to you, Chairman.
Well, he said he was going to ban it. Is there a timeline for finalizing the ban, or you know anything about what he's going to do in terms of finalizing a ban?
I can't comment on that. What I can comment on is that we continue to do our work under TSCA to complete our asbestos risk evaluation on time this year.
Well, let me go back to this risk evaluation. One of my biggest concerns with your asbestos risk evaluation is the agency's position that you have the discretion to exclude significant exposures. So let me ask, the scoping document for the asbestos risk evaluation excluded exposure, and I quote, to legacy asbestos from EPA's risk evaluation. Is that correct?
Yes.
Okay. Have you changed course, or will the risk evaluation, which is due to be published next month, exclude the risk from legacy asbestos?
We are not ignoring the legacy asbestos problem, Representative. However, we do believe that there are extensive federal, local, and state requirements that address legacy asbestos if it is to be disturbed and removed, demolished, essentially.
You've also excluded exposure from disposal of legacy asbestos, despite the fact that disposal is explicitly included in the statute. Is that correct? That you have excluded exposure from disposal?
We are looking at the ongoing uses of asbestos in commerce today, and that is in the manufacturing process.
But I mean, won't you acknowledge that disposal is explicitly included in the statute?
Absolutely. TSCA defines use as processing, manufacture, import, disposal, et cetera, yeah.
Well, then how do you exclude exposure from disposal?
In formulating that scoping document, there was a determination made, which certainly through the peer review process and through the transparent process we'll follow this summer could certainly be questioned whether that was a reasonable assumption by our scientific experts that could come up.
I mean, the exclusion of the legacy asbestos and the legacy disposal is, I think, a major reason why I think Section 3 of my bill is so important. But I'm also concerned that you've excluded relevant cancers, relevant forms of asbestos, significant exposure pathways, and I think you're failing to meet the letter and spirit of the law by failing to evaluate firefighters as a relevant, disproportionately exposed subpopulation. Have you reversed course any of those things that I just mentioned?
We have not had discussions around those items. I'd be happy to follow up with your office to talk more about them.
I appreciate that. In my view, these are fatal flaws in your risk evaluation that are going to doom any future regulatory action. And as one of the original drafters of the Lautenberg Act, I can tell you that we did not intend for EPA to conduct risk evaluations that ignore major drivers of risk, like the risks posed by legacy asbestos. And I don't think your actions implementing TSCA comport with the law. I don't think you're moving towards a ban, even though Mr. Wheeler said so. And so I urge my colleagues to join us in supporting the bill, and that's why we need to have this bill that bans asbestos once and for all. Can I just ask a question? Well, there's not much time, but pigment violet 29, as part of your risk evaluation for pigment violet 29, you identified several studies that have been submitted to the European Chemicals Agency that would be relevant to your evaluation. Is that correct?
That is correct.
And you tried to identify U.S. entities that had those studies in order to inform your risk evaluation. Is that correct?
Right.
You then reached out to the EU entities in possession of those studies so you could use them in your risk evaluation, correct? And then you received those studies from the EU entities and used them in your risk evaluation. That's correct as well?
That is correct.
All right. I think I've run out of time, Mr. Chairman, on that. But I will... We'll ask you to get back to us on what you offered before on the asbestos.
Be happy to.
Thank you.
The gentleman yields back. The chair now recognizes a gentleman from the state of South Carolina. Mr. Duncan, for 5 minutes, please.
Thank you, Mr. Chairman, and thank the witness for being here. Administrator Dunn, I'm struggling with how some of the provisions of this bill will be used. H.R. 1603 requires a legacy use consensus or census of asbestos within 18 months of enactment. I'm from South Carolina. I lived South Carolina, North Carolina, Virginia. We have textile communities all over our states. And those textile communities, back in the day, the local textile mill built houses for its employees. Many of those houses were built prior to 1950. Many of those houses have asbestos siding still. A lot of those houses have been renovated by the owners, and that asbestos siding has been covered up by more modern siding, right? So keep that in mind. How challenging would it be for the EPA to coordinate with the Departments of Labor and Health and Human Services to produce a report that accurately estimates the presence of asbestos in every residential, commercial, industrial, public, and school buildings and the extent of exposure and risk not later than 18 months after enactment? Folks, there's no way in Washington that you can determine every house just in the South. That's not counting all the northern communities that are like textile communities in the South where there might be asbestos in the siding. No way. And definitely not in 18 months. And so the number of buildings nationwide, the amount of asbestos remaining in the U.S., how hard is that going to be for you?
We identified this provision of the bill as being a significant challenge to do well. We pride ourselves at EPA when asked to undertake assessments of being comprehensive, thorough, and accurate. And under 18 months, we are questioning whether we could come close to.
Are you going to send every homeowner, every landlord a questionnaire and say, does the house that you own have asbestos siding?
We had not even begun to think about how we would implement it, but I think even getting responses.
That's a heck of a lot of properties.
We do not have the ability to enter private property.
We've probably already identified most of the public buildings and school buildings and that sort of thing that may or may not have asbestos, but then those school districts are going to have to spend a lot of resources looking at the insulation on in their boiler room, on their pipes, to look at their siding, their roofing insulation materials. How do you plan to leverage resources without any additional funding?
That would be a significant challenge, and as I stated earlier, when asbestos is intact and not disturbed, it does not generally pose a risk.
Right. Do you have the resources and employees to complete this report without disrupting ongoing activities at the agency?
It would impact.
I mean, are you going to have to pull people from other projects to conduct a survey and provide a report in 18 months?
I'm not sure our colleagues in other offices with other statutory obligations would look kindly on us borrowing their people, but I think we would have a very difficult job getting this work done with our existing resources.
Right. So H.R. 1603 requires the president rather than administrator to determine whether an exemption is granted. It also prevents the use of waiver by EPA to protect national defense. Since the exemption only applies national security and limits the president's ability to use asbestos in the interest of the nation in mind, does this limitation on the president infringe upon the president's Article 2, Section 2 powers under the Constitution, in your opinion?
We have not fully assessed the implications of this provision, but we did identify it as of concern because Section 22 of TSCA already has a definition of national defense that appears to be in conflict with what's in the bill.
Right. Well, I appreciate you being here. Let me just make a point that as this bill moves forward, there will probably be amendments proposed that will give more timeline if we're going to do a census. I think there's an agreement that asbestos in certain forms and areas are toxic and are detrimental to the health of folks in the nation, but there's got to be some common sense injected into legislation, and I hope to do that in full committee and markup. I thank you for being here.
Would the gentleman yield
yeah.
for his last?
Yeah.
I just want to check for the record, if we could check the record for the Wheeler hearing and make sure. I think he said he would like to. Well, I would check the record and make sure that that's what the administrator said. I'll yield back.
Yeah. I reclaim my time and I yield back, Mr. Chairman.
The gentleman yields back. The chair now recognizes the gentleman from the state of California, Representative McNerney, for 5 minutes.
Well, I thank the chairman, and I thank Ms. Dunn for testifying this morning. But I want to focus on an important part of the legislation under consideration, namely the definition of asbestos. This bill makes clear that the ban of asbestos should include several forms that were excluded from the EPA's proposed ban back in 1989, because we didn't know back then that they had, some of these other forms had the same properties and same risks. This includes several of the Libby abiobiols that have been connected to the terrible burden of disease in Libby, Montana. I have a document here, a memorandum from career staff in EPA's Region 10 office that was sent to your office regarding the proposed asbestos significant new rural use, or SNUR, raising concerns about the definition of asbestos in that document. Now, I'll go over some parts of the document with you. The career staff in Region 10 raised a concern about the proposed SNUR because it focused only on the 6 forms of asbestos covered in the original 1989 ban. Does the final SNUR focus only on those 6 forms?
We do not redefine asbestos for the purposes of the final action we took in April. We are using the definition of asbestos in Title II of the statute, which does not include the 2 fibers that you're referring to, richterite and winchite.
So we are restricting this to only the 6 forms. That's a yes or no answer.
We're using the current statutory definition.
This Region 10 memo cites W.R. Grace Superfund case from 2002 concerning the Libby contaminants, where the federal district court ruled that the Libby amniophils are in fact asbestos. Are you aware of that case?
I'm not familiar with that case.
Okay, I would recommend that you familiarize yourself. Region 10 memo also states, and I'm quoting, the EPA is now aware that there are more than 6 types of asbestos fiber, including several abiophiles, which the EPA has known about since the 1990s. Do you agree with that statement, that the EPA was aware that there are other forms?
I do not have a position on that statement. We are using the definition of asbestos in the Act.
All right. This memo is focused on the asbestos SNUR, but the same concerns hold true for overall risk evaluation and possible risk management. Is your risk evaluation for asbestos going to include exposures to all forms of asbestos?
Our risk evaluation is looking at the limited ongoing industrial uses of asbestos today. There are approximately 5 or 6
Additional types?
uses that are still ongoing.
Uses? Mm-hmm. So you'll consider just the 6 types in these 5 or 6 uses?
Right. Exactly, yes. And the types of asbestos fibers that are used in these ongoing industrial manufacturing settings are within the current definition of asbestos in the statute.
So it seems to me like you're missing out on quite a bit of risk with regard to additional asbestos types that are damaging the American public. Is that right?
Well, we feel very confident that looking at the ongoing conditions of use of asbestos in these industrial applications will allow us to do a very protective risk evaluation.
Well, I think it's important to define and ban all forms of asbestos, not just the 6 we knew about 30 years ago. It's clear that an accurate definition of asbestos in this bill is one of the most important reasons that this bill will be more protective than other actions coming out of the EPA. Mr. Chairman, I thank you for holding the hearing, and I yield back.
Gentleman yields back. The chair now recognizes the gentleman from the state of Georgia, Representative Carter, for 5 minutes, please.
Thank you, Mr. Chairman, and thank you, Ms. Dunn, for being here. I appreciate it very much. This is a very important subject for all of us. Let me ask just a couple of broad, simple questions to begin with. Since the Toxic Substances Control Act was passed in 2016, what kind of a extra authority has it given EPA? I mean, you have some explicit authorities as a result of that. Can you explain those to me very quickly?
Yes, it's a very powerful law. It puts us on a very aggressive time frame to look at chemicals. Some of the things we're most proud of, we've just completed an inventory of chemicals in the United States. It was estimated that there were over 83,000 chemicals in commerce in the U.S. We have checked with the manufacturers and importers, and we just announced and finalized that the list is actually half. It's about 40,000 chemicals in commerce in the United States. So we cut the list in half. That cuts our workload in half. But we have to, bit by bit, work our way through that list. We're starting with the chemicals on the 2014 TSCA work plan. We are starting with the first 10 chemicals that we've been talking about today, include asbestos. We have already named 20 high-priority chemicals that we are going to start looking at next year, as well as 20 lower-priority chemicals.
Right. And certainly this is important for a number of reasons. Particularly in my district, I assume that a lot of these go through ports and seaports. And being the home of 2 major seaports in coastal Georgia, this is extremely important for us. So our constituents are very concerned about this and about the work you've been doing. Now, it's my understanding that you're currently reviewing the use of asbestos.
We are.
And that you're going to be releasing your draft findings soon. Do you know when that'll be?
We anticipate it will be, I will say, before the end of the late summer. We have a scientific review panel that has to review it, and most of those individuals are academics. The best time to get academics is when they are not teaching classes, so we want to make sure that that information is available for them to meet and review in June, July, and August of this summer.
Okay. Well, I think it's clear from the hearing today that none of us, want to see anybody harmed. We want protection for everyone. I'll be quite honest with you. It's my understanding the majority of asbestos is no longer being in production, is no longer in use. But is any? I didn't realize there were any forms of asbestos out there.
There's only 5 ongoing limited industrial uses of asbestos in the United States today. It's in manufacturing. All of the asbestos that's used is imported. So there is no ongoing asbestos mining in the United States anymore. And that's something that would be covered by our activity. that we took a few weeks
Whoa,
ago.
whoa, 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 hold on. I don't mean to interrupt you, but you raised my concern here. If it's coming from out of the country, then we're not having any regulation over it before it gets here? Are we checking it when it gets here?
Well, any import of a chemical does have to be checked at the border.
But specifically asbestos, that's what I'm concerned
As
with here.
asbestos is coming in, what we are doing right now is a comprehensive risk evaluation of that type of asbestos in the uses that it is still being used in the United States, which is in the manufacture of brake blocks for oil drilling, automotive brakes, vehicle friction products, some gaskets, and a couple of chemical production.
Okay, specific to those that you just
Yes.
mentioned, what is EPA doing to guard against any problems there may be with those specific ones that you just listed?
Well, any imports of chemicals have to be handled with customs and border protection. as well.
So you're grouping them into all chemicals, not just focusing on these that you just listed.
We manage the import of all.
Well, you see where I'm coming from. It would just appear to me that you would be more concerned because we know the dangers of asbestos. It would seem to me that you'd be more concerned with those than you would be for just generalizing them and putting them into a broad group.
Mm-hmm. No, I understand where you're coming from. Again, the manufacturers, those companies that are using asbestos in these limited applications certainly are trying to produce a high-quality product. They also have a business interest in ensuring that all the ingredients that they use are safe in how they're using them.
Oh, okay, I'm still a little concerned about that. So please, let's take that as being noted. I appreciate it. Thank you very much again for being here, and I yield back.
Gentleman yields back. The chair now recognizes the gentlelady from the state of California, Representative Matsui, for 5 minutes. Representative?
Thank you, Mr. Chairman. You know, since this hearing was noticed, my colleagues and I have heard from an array of industries that rely upon the chlor-alkali industry to produce chlorine and caustic soda. Those industries are concerned about a possible disruption in the chlor-alkali industry. So I want to ask a few questions about how and why some members of that industry use asbestos. Roughly 1/3 of the chlor-alkali industry uses asbestos diaphragms in their production process. Is that right?
I don't have the statistic in front of me, but that sounds
does seem right?
ballpark.
Okay. What information have you sought from those members of this industry, and what information have they given you about their plans to replace their asbestos diaphragms with other diaphragms?
We have collected extensive information from the manufacturers. I would like to be able to get back to you, Representative, on what information they may have provided to us around alternatives or plans to replace. I don't have that information.
Okay. Now, several years ago, a large segment of the chlor-alkali industry changed over their plants to phase out dangerous mercury in their processes. Did that transition disrupt the chlorine or caustic soda markets?
I would have to check with our experts and get back to you on that, Representative.
Okay. Isn't it true that non-asbestos diaphragms used in other chlor-alkali plants are more energy efficient and have longer service life than asbestos?
Once again, with regard to some of these technical questions, I would be more than happy to consult with our career experts and provide that information back to you very quickly.
Okay, because my understanding is that it is more efficient so that those who use asbestos could realize energy and climate benefits in addition to the benefits of getting rid of the toxic asbestos. So I would really like that information. I think it's very important.
Absolutely.
Now, your agency has extensive authority under the TSCA to get data from manufacturers. What information has your agency requested from the chlorine-alkali industry about the exposures faced by its workers and by the workers who handle disposal of the diaphragms?
Well, in terms of preparing for our risk evaluation, we have requested extensive information from the manufacturers who are using asbestos in the chlor-alkali production. We have a number of studies regarding exposures provided to us, and I can find out. We try to have a very transparent process and make all of our information available.
Okay. What information have you requested about health monitoring and incidence of cancer among workers in the chlor-alkali industry?
So again, in doing our comprehensive risk evaluation, we look for all types of information with regard to exposures, illness, et cetera.
And you have that information?
If we have the information, I will go back and talk to our staff and see if we can make that available.
Okay. What can you tell us about the fate of the asbestos diaphragms used in this industry? How are they disposed? Have they contributed to contamination of land or water?
Again, I apologize, that's a technical question, but I would like to be able to get back to you on that. I do not have that information with me at this moment.
Well, I think it's very important that we understand the risk to workers in that industry and also the alternatives that might be available to the members of the industry.
And the information that you're asking about is all included in our risk evaluation of chlor-alkali production. So all of those forms of releases, disposal, manufacturing will all be addressed in the document.
In the document.
That we are completing and will be available for public review and peer review late this summer.
So does that also include the information I asked you previously that you can get back to me on, or is that additional information you need
Well,
to get
I
to me?
certainly wouldn't make you wait for that, so I will make sure that we get back to you more promptly.
Okay, I expect to get as promptly as possible.
Absolutely.
Thank you, and I yield back.
The gentlelady yields back. The chair now recognizes the Republican leader of the full committee, Mr. Weldon, for 5 minutes, please.
Thank you, Mr. Chairman. And I don't know, you may have to get back to me on this one for the record. I'm told 36% of domestic chlorine production is manufactured using a totally enclosed process that does use an asbestos filter. Assuming H.R. 1603 becomes law and the ability to continue this process ceases, the Safe Drinking Water Act has provisions, and we reauthorized that in a bipartisan way in the last Congress, that requires access to chlorine, to chemicals for public water systems that disinfect their water with chlorine. Do you read the language in H.R. 1603 to create a potential conflict between its provisions and that section of the Safe Drinking Water Act? I know that's pretty technical, but
It's an important topic, and what I would like to do is bring this back to our Office of Water and ask for their perspective on it and get back to you.
yeah, I'd like that. That'd be, and I understand, because we're obviously very concerned as we go down this path. What are the unintended consequences? And you know, we don't want to get to a situation where water utilities may not be able to get what they need to be compliant with safe drinking water. EPA recently denied petitions for collecting additional information under TSCA asbestos. Why?
We received 2 petitions. We looked at both of them very carefully. We have published in the Federal Register detailed reasons why we denied, but in short, due to our comprehensive assessment of the limited ongoing uses of asbestos today in the industrial sector, we did not believe that the petitions would, the actions they were asking us to take and the information they were asking us to collect would enhance our knowledge.
Okay, so that's why you would consider the information petition
Would not
be helpful?
Add information to EPA that we did not already have.
Okay, all right. In carrying out its work under TSCA, Section 6, has EPA missed any of what some of us would argue were pretty aggressive timelines Congress placed on the agency, either as it relates to asbestos or any of the other chemicals you're evaluating? Are you on target in time?
We are proud to say that we have met every chemical-related deadline under TSCA.
Including asbestos?
We are on track to meet asbestos on time.
All right, because those were pretty aggressive. I mean, sometimes when we legislate, we put down timelines, and some agencies are better at meeting those than others, and sometimes our timing's off, but you're on target.
We are on target. We are working very, very hard. Our team is doing a great job.
All right, those are the questions I had for now. I look forward to hearing back from you, Ms. Dunn, and thanks for your leadership over there.
You.
And Mr. Chair, I yield back.
The chair yields back. The gentleman yields back. The chair now recognizes the Representative from California, Representative Ruiz, for 5 minutes, please.
Thank you, Chairman. Thank you, Assistant Administrator Dunn, for being here. I support the efforts to decrease the use of asbestos. In fact, eliminating the risk of asbestos causing lung cancer, mesothelioma, asbestosis, and other scarring of the lung tissue that can greatly and terribly affect a person's quality of life is something that we should all strive to do, given that it is so horrible to experience shortness of breath. It is devastating for families when somebody gets diagnosed with lung cancers, only simply because they were just doing their job, and those responsible to ensure that they had a safe job to work in failed to adequately prohibit and prevent those risks from happening in the first place. It is still astonishing that in 2019 we're still manufacturing and just recently imported tons of asbestos from Russia, China, and Brazil, and still processing new asbestos materials in this country, given all the science and all the public health dilemmas that our public health experts have already identified and are warning us about. Many of us have been following the court cases concerning exposure to asbestos as a contaminant in talc powder. Talc powder. Use that to get beach sand off your legs. Use that in children and babies. But I doubt many realize that it is still legal to have asbestos as a contaminant in consumer products. This bill would change that. And under this bill, the manufacture and processing of asbestos, even as a contaminant, would be banned. So to me, this is an incredibly important part of this bill, whether it is makeup sold to kids and teenagers, talc powder sold for babies, potting soil or other products. Our products should be asbestos-free, period. And I want to make sure that we get this part right. So, Assistant Administrator Dunn, I have a couple of technical questions for you. The bill uses the term impurity because the term appears in your TSCA regulations already. How do you understand the term impurity?
So, thank you so much. This is an important issue, and I understand the concern with trace elements of asbestos in consumer products.
So the term impurity, how do you define
We
the term
currently
impurity?
define impurity as material containing more than 1% asbestos by weight.
Okay. And so I've heard from some of the stakeholders that the word contaminant might be more clear. In your view, is the term contaminant different from impurity?
We have not conducted an assessment of whether a different word would be more effective.
Can you take that back and respond to my question in
We
writing?
could certainly take a look at that for you.
Because I think that would be important, and because I think that the question I want to ask is, would we be missing anything by not including the word contaminant?
I understand your question, and we will make sure that we get back to you. As noted, EPA provides technical assistance to Congress as Congress
Does
is drafting
EPA have a technical definition of contaminant?
We may have a definition under other programs. It's certainly an important term in the Superfund program. I am not aware of it having a meaning in this law.
So I want to make sure that that this bill is clear that what we are intending, which is to ban asbestos in products, whether it be on purpose or by accident, as an impurity, a contaminant, ingredient, anything, just completely not in the products. In your view, is the bill clear on that point?
We continue to be available to provide technical assistance. We do think that some clarity around, for example, the definition would be needed, the 1%. How much are we talking about? There are trace elements, as you mentioned, of asbestos in a variety of products.
Okay. Thank you. That's all my questions. Yield back.
Thank you. The gentleman yields back, and now the chair recognizes the gentleman from Virginia, the very patient Representative Keechan.
The penalty for being tardy, Mr. Chairman. Thank you. Assistant Administrator Dunn, I'm going to ask you some questions about the significant new use rule. Hopefully they'll be brief and straightforward, but let's see if we can't work together on that. When EPA issues a significant new use rule, identifying a new use as significant, is that use banned?
The terminology can be a bit confusing. A significant new use means that the use, it would be new, and EPA would have to review it. So the effect is that it is not ongoing today, and if someone were to want to commence those activities, they would have to come to us under the significant new use rule and propose essentially a significant new use of asbestos. An example could be to use it in roofing tiles, and EPA would conduct a risk evaluation of whether that could be done safely.
So as I hear your answer, then even when you issue the rule, you leave the door open for some sort of use. Is that correct?
The door is open. We are not aware of anyone who is planning on taking advantage of bringing back these dormant uses of asbestos.
Okay, at the present time.
At the present time, we are not aware, and EPA would have to review any such proposal.
Okay. Do you foresee the possibility that you would approve a pre-manufacture notice for asbestos use listed in the significant new use rule?
While I can't predispose how we might come out, I think it would be highly unlikely that we would find some of those legacy uses to be able to be recommenced in a safe manner in the United States. There's a reason that they've been dormant and that no one is pursuing them.
And I appreciate your candor, but it still sounds like to me that there is that possibility, no matter how remote.
Under our legal authority, we have to do the risk evaluation before we can ban.
You know, I don't think we should allow the possibility of new uses. We should be getting asbestos out of our products and out of our commerce and not offering a pathway back to market for uses that we've abandoned decades ago. Was the significant use rule required by statute, or did you do it voluntarily, or did the agency do it voluntarily?
The agency undertook it to close the loophole left from the lawsuit that in 1991, where EPA in 1989 tried to ban all of these uses and was unsuccessful through litigation. And so we've now closed that loophole. That we're the first administration to take action in 30 years under TSCA on asbestos.
Did you have contacts, or did the agency have contacts with the chemical industry before the rule was issued?
I did not have contacts. I can't speak to everyone in the agency, but I certainly did not.
Will you provide the committee with your office's correspondence with the American Chemistry Council and chemical manufacturers regarding the asbestos significant new use rule?
I understand that we regularly provide documents to Congress, and I will ask our Office of Congressional Affairs to follow up to provide you what you're seeking.
Thank you very much. I yield back, Mr. Chairman.
The gentleman yields back. That concludes our first panel. And we again thank our Assistant Administrator, Dunn. Thank you for joining us today. At this time, I ask that staff prepare the witness table so that we may begin our second panel shortly.
Thank you.
Thank you, Administrator. Check you.
Start in a second.
Okay, right?
Yeah, we can start.
Okay, we'll now hear testimony from private sector stakeholders on this legislation. And we have 4 witnesses on our second panel. And I'll introduce those individuals. We have Ms. Linda Reinstein, co-founder of Asbestos Disease Awareness Organization. We have Ms. Rebecca Reindell, Senior Safety and Health Specialist on behalf of the AFL-CIO. We have Mr. Walls, first name, sir. Michael? Mr. Michael Walls, Vice President of Regulatory and Technical Affairs, American Chemistry Council, and Dr. Celeste Monfortin, lecturer, Texas State University, on behalf of the American Public Health Association. We want to thank our witnesses for joining us today. We look forward to your testimony, and at this time, the Chair recognizes Ms. Reinstein for her opening statement. Thank you so much, and you have 5 minutes with no lights.
Thank you, Chairman Tonko, Ranking Member Shimkus, members of the committee, for giving me the honor and the opportunity to testify in support of H.R. 1603, the Alan Reinstein Ban Asbestos Now Act, RBAN. My written testimony has been submitted for the record. I'm neither a lobbyist or an attorney. I am a mesothelioma widow and the co-founder of the Asbestos Disease Awareness Organization, ADAO, an independent nonprofit dedicated to preventing exposure to asbestos to eliminate deadly diseases that it causes. For the 5th time, I'm testifying on behalf of ADAO, but also your constituents who suffer from or have been silenced by asbestos-caused diseases. Today's ban asbestos legislation hearing is a landmark step forward for public health. And I'm honored to have H.R. 1603 named after my husband, but it's really for the hundreds of thousands of Allens who've paid a price for this man-made disaster with their lives. My daughter, Emily, is sitting to my left. She was just 10 when her father, Alan, was diagnosed with mesothelioma. He opted for a radical procedure to remove a rib, resect his left lung, strip off his pericardium, and surgically replace his diaphragm in hopes for more time with us. He fought a hard 3-year battle, and like we know, mesothelioma patients rarely win. He died 3 years later with Emily and myself by his side. This picture on the table represents my husband and the hundreds of thousands of Americans who die painful, premature, and preventable deaths. Emily and I are not alone. Each day, more than 100 Americans die from mesothelioma, lung, ovarian, laryngeal cancers, asbestosis, and other pleural diseases. Yet, imports continue. Alarmingly, my new research, which you will all have on the back table, has revealed that since the EPA tried to ban asbestos and it was overturned in 1991, 1 million Americans have died from these preventable diseases. This snapshot is only a small piece of time, because you can imagine over the past 100 years how many Americans have died from these preventable diseases. Think for just one moment, not about our family, about the millions of families that have loved and lost loved ones due to this chemical, while our government has done nothing. 30 years after EPA tried to ban asbestos, the facts remain irrefutable. All forms of asbestos, including chrysotile, are a known human carcinogen. There is no safe or controlled use of asbestos. Knowing the unreasonable risk, we have allowed over 300,000 metric tons to be imported and used in the past 28 years. Now, companies recognizing the risks decades ago have actually transitioned to safer and economical substitutes. However, the chlor-alkali industry has refused. Today, Olin Corporation, Occidental Chemical Corporation, Axial Westlake Corporation are still importing, using, and lobbying for an exemption. To be clear, they use chrysotile asbestos diaphragms to produce chlorine and caustic soda, but there are 3 methods. This is just one. Our research reveals only 1% of their chlorine production is for drinking water. The rest is for industrial chlorine uses. Last year, this industry imported 750 metric tons of raw asbestos from Russia and Brazil, 750 metric tons. Now, there are numerous asbestos exposure pathways from mining, transporting between port to plants, within the plants, and disposal. That is a massive amount of opportunities. It is beyond a glove box. EPA risk evaluations are excluding the asbestos that we find, the legacy in our homes, schools, and workplaces. And let me tell you, an impurity 1% by weight is not protective. If you have a 100-pound bag of play sand, could you really have a pound of asbestos and have it be legal? As a widow, I say no. They're also excluding various cancers, which you've heard the committee describe: ovarian, laryngeal, asbestosis, other diseases. During the past decade, since I've been coming to Washington, actually it's 15 years, asbestos has been the poster child for meaningful TSCA reform. And I agree with Ranking Member Shimkus. I hate asbestos. And the EPA has failed to do their job. We can't wait and hope that the EPA narrow risk evaluation will lead to a ban while the agency is failing. And Congress must expeditiously move this bill forward. And I look forward to answering your questions, and thank you for your leadership.
Thank you, Ms. Reinstein, for your very compelling testimony. Ms. Reindel, you're recognized for 5 minutes, please.
Thank you. Chairman Tonko, Ranking Member Shimkus, and members of the committee. Chairman Tonko, Chairman Tonko, Ranking Member Shimkus, and members of the committee, I appreciate the opportunity to testify today on behalf of the AFL-CIO on this legislation to ban asbestos. My full written testimony has been submitted to the committee for the record. The AFL-CIO is a federation of 55 national and international unions, and we represent more than 12.5 million union members who work side by side millions of non-unionized workers. Over the last 4 decades, the AFL-CIO and our affiliated unions have acted to protect workers from the hazards of asbestos exposure through the development and implementation of asbestos regulations and legislation. We strongly support this federal legislation to ban asbestos, H.R. 1603. We applaud the efforts of Representative Bonamici and this committee to champion and guide this legislation in the House, and the efforts of Senator Merkley to initiate similar legislation in the Senate. Asbestos is the poster child of the historical failure under the original Toxic Substance Control Act to protect people from a chemical known to have very serious health effects at very low levels of exposure and known to be extremely difficult to control over its long lifespan. In the development of the 2016 bipartisan Frank-Lautenberg Act, no one doubted its aim to fix the law to ban asbestos definitively. But we are here today because EPA has not used that new authority and responsibility, and we are here to further amend that law to finally protect working people and to save lives. One of the worst things about asbestos is that most people think it is no longer a problem in the U.S., when in fact it is the most significant and devastating occupational health disaster that has lasted over a century in this country. Hundreds of thousands have died. The number of asbestos-related deaths that continue today are worse than experts in the 1980s projected them to be now. Tens of thousands each year. The number of mesothelioma cases in 2017 is actually the highest number of the data that is pulled since 1999. Especially troubling, we're seeing workers under the age of 55 with significant levels of asbestos disease and are dying. And those are workers who have entered the job market after the 1980s and after asbestos regulations were adopted. An insulator in Chicago started the trade in 1993 and was screened in 2016. He recently died at the age of 45 with elevated levels of asbestos fibers in his lungs. The legacy of asbestos, unfortunately, is very much with us, and we are passing it on to the next generation. As other industrialized countries are realizing the magnitude of this continuing exposures and disease from legacy asbestos, the asbestos installed 40 to 70 years ago, they are not only banning asbestos from commerce, they are also conducting national assessments to understand where it is, how much of it there is, and they're developing strategic plans to safely remove it and dispose of it. But in the U.S., we don't really know that information. And if we don't know, we can't control exposures to it. Workers don't know if they are repairing or installing something located next to asbestos materials. They don't know if they are replacing flooring containing asbestos. The last time the U.S. has profiled the scope of the asbestos problem was in the 1980s, despite its widespread existence throughout facilities all over the country, in refineries, in powerhouses, in schools, in hospitals, in steel factories, and in other structures. That material installed decades ago is now falling apart and being disturbed. As asbestos ages and weathers different conditions, such as moisture, vibration, it deteriorates and it becomes friable over time, which puts those working near it at much higher risk. The worst occupational exposures tend to be in construction, abatement, renovation, routine maintenance work, and custodial activities, but because there's no safe level of exposure to asbestos, any worker performing activities near asbestos is at risk. In its 1994 asbestos standard, OSHA recognized and fully acknowledged that under the standard, workers exposed to continue to be at significant risk of asbestos disease. Instead of banning all new uses of asbestos and conducting a full assessment to understand the real magnitude and the real impact of the problem, EPA recently created a mechanism for the agency to actually approve new uses of asbestos. They've misled the public by telling us that they are strengthening regulation of asbestos. The legislation here today is so important. It bans future uses of asbestos without loopholes, and it begins the very difficult and critical work of controlling the problem in front of us, the deadly consequences of legacy uses. OSHA cannot do this. EPA has not done this. We urge the committee and Congress to move forward without delay and enact this life-saving bill. Thank you, and I'm happy to answer any questions.
Ms. Rindell, thank you. We now move to Mr. Michael Walls. You are recognized, sir, for 5 minutes.
Chairman Tonko, Ranking Member Shimkus, and members of the subcommittee, good morning. I'm Mike Walls, the Vice President for Regulatory and Technical Affairs at the American Chemistry Council. I was the chemical industry's principal technical representative in the discussions that resulted in the 2016 amendments to the Toxic Substances Control Act. And I'm here today to reinforce our industry's commitment to full and effective implementation of those amendments. Now, the 2016 amendments were a significant bipartisan achievement. In those amendments, Congress established a process to reinforce public confidence in EPA's management and assessment of new and existing chemicals. The amendments require the agency to have sufficient information to make an affirmative regulatory decision on chemicals in an open and transparent way. And a key element of those amendments was a requirement that EPA systematically evaluate the risks of high-priority substances and regulate their uses when necessary, subject to strict deadlines for action. Now, you've already heard that in December 2016, EPA identified asbestos as one of the first 10 substances undergoing evaluation. You know that the assessment's supposed to come forward for public comment later this year, that the EPA expects to meet its deadline in December of this year. Under the terms of the 2016 amendments, EPA must take into account both the hazards and the risks of exposure under specific conditions of use. EPA cannot consider costs and benefits in the evaluation of those risks, but once it identifies unreasonable risks, EPA must then regulate to ensure that any unreasonable risks are managed appropriately. Now, our industry is committed to effective and efficient implementation of the 2016 amendments. In part, that commitment is reflected in the fact that ACC member companies provided information to EPA specific to the use of asbestos in chlorine production. This included information on the transportation, use, and disposal of information in that condition of use, including exposure information. Our company's use of asbestos in the production of chlorine is highly regulated and controlled to prevent exposures to humans in the environment. This includes a specific national emissions standard for hazardous air pollutants, or a NESHAP, under the Clean Air Act. You've already heard today that 1/3 of total U.S. production of chlorine and sodium hydroxide relies on closed-system chrysotile asbestos diaphragm cells. Those cells separate chlorine from its co-product, sodium hydroxide, while ensuring that those substances are contained in the cell. Human exposures are prevented by the rigorous use of personal protective equipment, as well as appropriate engineering controls, routine maintenance, and rigorous training. Federal regulations also govern the disposal of spent asbestos diaphragms. Now, chlorine is essential to ensuring access to safe drinking water for millions of American families. It also enables life-saving healthcare and pharmaceutical products, energy resources like solar panels and wind turbines, and much more. A blanket ban that includes the chlor-alkali industry's use of asbestos would have, in our view, a significant impact on the supply of chlorine. That, in turn, will jeopardize public health and increase prices for a wide range of vital consumer and industrial goods. I want to be absolutely clear that ACC believes that EPA's ongoing risk evaluation of asbestos properly covers the use of asbestos in chlorine production. In our view, that use is and will continue to be appropriately controlled to ensure that it does not pose an unreasonable risk. Now, in 1989, EPA recognized that a ban on the use of asbestos in chlorine production was not appropriate. ACC opposes H.R. 1603 because it would set an unfortunate precedent for legislating risk management actions on substances subject to TSCA. We believe that EPA must be given the chance to complete its ongoing assessment. We believe that the system Congress approved in 2016 must be given a chance to work. Imposition of a blanket ban on asbestos use without the benefit of EPA's risk evaluation and without the benefit of information on appropriate risk management measures undermines the process that was the basis for Congress's bipartisan agreement in 2016. Thank you very much for the opportunity to provide this testimony. I look forward to your questions.
Thank you, Mr. Walls. And finally, we'll hear from Dr. Monforton, and you're recognized for 5 minutes, please.
Thank you, Chairman Tonko, Ranking Member Shimkus, and members of the subcommittee. I'm Dr. Celeste Monforton. I'm a lecturer at Texas State University. I have a doctorate and a master's in public health, and I've worked in this field for nearly 3 decades, including at OSHA and MSHA in the Department of Labor. I'm testifying today on behalf of the American Public Health Association, and I currently serve on the association's action board. I ask that my written statement and attachments be included in the record. APHA's mission is to improve the health of the public and to achieve equity and health status. Accomplishing these goals requires focus and attention on numerous social determinants of health, including exposure to toxic substances in the outdoors, in schools, in homes, and in workplaces. A decade ago, APHA called for a complete ban on asbestos. We have remained steadfast in this position, and it's the reason that APHA strongly supports H.R. 1603. There is no debate in the public health community that asbestos is a carcinogen, and there is no safe level of exposure. The comprehensive ban required under 1603 is on very strong scientific foundation. APHA applauded passage of the Lautenberg Chemical Safety Act and the decision by the Obama administration to choose asbestos as one of the first 10 chemicals subject to risk evaluation. EPA's recent decisions, however, call into question the current administration's willingness and ability to address the threat that asbestos poses to the public health. In its scoping document and problem formulation, EPA has essentially put a stake in the ground about what they will consider in their risk evaluation. These decisions include excluding cancers that are associated with asbestos exposure, including of the larynx, pharynx, ovaries, as well as pleural disease, excluding the exposure to asbestos-containing materials in the buildings, excluding exposure to asbestos in air, soil, and water, including disposal of asbestos-containing waste. With respect to the reporting requirements and the analysis that the bill calls for with EPA, Labor Department, and HHS, it's critically important because we cannot prevent asbestos-related cancers if we don't have accurate data on where it's located, what condition it's in, how it's handled and disposed, and how many people are exposed to it. We also don't know who is importing asbestos, where it's being shipped, and where it ends up. H.R. 1603 will help to fill this significant information gap by requiring EPA and other agencies to assemble data to answer these questions. The bill embraces the fundamental principle of the public's right to know and will provide the information necessary to develop protective risk management plans. Asbestos is a potent carcinogen. More than 60 countries have banned asbestos because they recognize its grave risk to public health. It is long past the U.S. to do the same. Cancer takes a physical and emotional toll on a patient and their family. Cancer has economic consequences, more than $80 billion in direct medical care costs alone. Add to that the lost time from school and work, productivity, travel, and all the other expenses that go along with having a serious illness. Preventing cancer makes economic sense. On a personal note, at age 49, I developed cancer that had already spread to my lymph nodes. I lost more than a year of my life undergoing treatment. Cancer is scary. Like many cancer patients, I wondered, how could this have been prevented? For so many cancers, we don't know the answer. We don't know the cause. But for asbestos-related cancer, for mesothelioma that killed Alan Reinstein, it is lethal. And we know exactly how to prevent asbestos-related cancers, eliminating exposure to asbestos. And that doesn't mean continuing to import it and claim that it can be handled safely. It's for this reason that APHA supports strong and comprehensive legislation that will ban asbestos, address the risk for the millions of metric tons of asbestos that's in buildings, homes, schools, and other structures, and assures the public's right to know. H.R. 1603 accomplishes these goals, and APHA wholeheartedly supports it. Thank you.
Thank you, Dr. Monforton, and thank you to all of our panelists for your presentations. That concludes our witnesses' opening statements. For our second panel, we now move to member questions, and I'll recognize myself for 5 minutes for questions. Mr. Walls, I asked this of Administrator Dunn, but I certainly want to get your thoughts. Over 60 other countries have managed to ban asbestos. I believe they're still able to treat their water and find safer alternatives for many other uses. Do you see any reason why the United States could not be able to transition away from asbestos-containing materials?
If your question, Mr. Tonko, is with respect to the chlor-alkali industry's transition away from asbestos, we certainly know that there are alternatives to asbestos diaphragm cells, but there are no drop-in replacements for those uses. We are talking about a transition time that's significant, that would cost hundreds of millions of dollars. It is true that in other countries they use other technologies. We even use some of those alternative technologies here in the United States. But it's not a simple matter of dropping in an alternative, switching the plant back on, and being able to produce. Under the bill as it's been presented, it imposes an immediate one-year ban, 1 year after enactment on all uses of asbestos. That would essentially create a significant shortage of chlorine in the United States market. It would eliminate 36% of U.S. chlorine in the market. The industry cannot respond in any time frame like this.
What would be a reasonable time frame by which to respond?
I think it would depend on the particular facility in question, Mr. Tonko. When you're talking, planning, the engineering, permitting, construction, testing, before you can start up a facility safely, et cetera, it would be a significant number of years.
Might I ask Dr. Monforton and our other two witnesses if they have thoughts on alternatives?
We do know that other countries have used alternatives. I actually have, I think, in my testimony information about only one of 75 plants in the European Union use chlorine in their use asbestos diaphragms in their chlorine production.
Japan has banned asbestos, France, specifically in the chlor-alkali industry. So it's obviously something that we can do. And from the Public Health Association's position, I mean, we certainly know how important clean drinking water is, and that chlorine is used in it, and you need chlorine as part of a residual at the end of the process, but that can be done without using asbestos diaphragms.
And Ms. Reinstein and Ms. Reindel, any thoughts on alternatives and perhaps how effectively and quickly others have moved
Thank you, Chairman
to those
Tonko.
alternatives?
I would like to respond to that on 2 points. The chlor-alkali industry has had 30 years since they got an exemption to embrace new technology and follow Europe to use membranes, and obviously mercury is being phased out. Other countries can do it. I was recently on a call, and I don't want to name the actually chlor-alkali producer. They said they can make a transition in 5 years. Other countries have done it within 3. Why not start? USGS states that the chlor-alkali industry is stockpiling asbestos now. 750 metric tons in 1 year is outrageous.
So, Ms. Reindel,
I don't have a comment on that.
are you recommending they should start now, Ms. Reinstein?
I think for the health of their workers, their industry, and the nation, it would be unconscionable. And I have to say, as I flew in last night, I was shocked to read Mr. Wall's testimony. They wrote they oppose H.R. 1603. So we're sitting at a table having a conversation, knowing that ACC goes flat out to say they oppose banning asbestos, or the bill as written.
Mr. Tonko, I think I need a chance to respond to that. We've been very clear that ACC's opposition to H.R. 1603 is exactly focused on the chlor-alkali industries, the impact on the chlor-alkali industry and the supply of chlorine in this nation. We certainly are not opposing a ban for all other uses of asbestos, and I just want to make that clear.
Well, I heard the hundreds of millions that it would cost, but I also heard the billions that it costs for those who have been impacted by illness. I have used all my time, so I will now yield to the leading Republican of the subcommittee, Mr. Shimkus, for 5 minutes.
Thank you, Mr. Chairman. For Mr. Walls, and it's on the same topic of chlorine and the issues. My understanding is that the diaphragm production technology accounts for 50% of all chlorine production in the United States, and that 72% of that diaphragm production technology comes from asbestos diaphragms. Is that correct? 36% of all chlorine production in the United States would need to be replaced if this bill becomes law.
Yes.
What are the practical effects in the short term from this loss?
Well, I think the most significant effects would be a ban on asbestos would eliminate 36% of the volume of chlorine in the U.S. market in the short term. Because chlorine is not traded because of its properties, et cetera, we don't ship chlorine across the ocean, for example. There are no opportunities to meet the reduction in volume by imports. Production of chlorine derivatives would also be reduced, and the imports of those derivatives would be increased. The U.S. is also a net exporter of caustic soda, or sodium hydroxide, which is the co-product of chlorine. Every time you make a ton of chlorine, you get 1.1 tons of sodium hydroxide. Eliminating caustic production will eliminate the trade surplus we currently have in that good, and encourage more imports of it. So we've done a study. We believe that the direct economic impacts would be a total of direct, indirect, and payroll-induced effects of 155,000 jobs, $9.7 billion in payroll, and $63 billion in U.S. economic output.
The non-asbestos diaphragm technology that could be more widely deployed to replace it is comprised of fluoropolymer fibers, or commonly known as PFAS compound. Is that correct?
Yes, that's one of the alternatives.
And we'll be talking about PFAS next week, I guess, right? If non-asbestos diaphragm technology isn't used as a replacement, there is a mercury cell-based technology and a membrane cell technology. Are these drop-in replacements?
No, mercury cell technology is being phased out. Very little of, if any, of U.S. production is produced with mercury cells. There is no currently available drop-in technology for asbestos.
Yeah, and I've been talking to some colleagues on this. It's not like we're not talking like replacing a coffee filter. I mean,
No. These are typically, so just to explain the process, from the time this imported asbestos arrives in a container, that container is sealed, the asbestos within it is packaged in roughly 40-pound plastic packages, put on a pallet. The pallet is wrapped in very heavy-duty plastic. The container is sealed and cannot be opened until it's at the facility and under conditions in which the potential exposures to asbestos can be controlled. The asbestos is wet deposited with complete protective equipment for the workers in an environment where exposures to the air are minimized. So what happens is this asbestos is wet deposited onto a frame, and when it's dried before it's put into the cell itself, this is essentially non-friable asbestos. It's in a matrix and bound in that matrix.
Going back just to the 36%, do Canada and Mexico produce enough chlorine to replace the 36% that could get lost if this became an immediate law and there'd be an immediate ban?
No. Canada and Mexico's chlorine production is typically used for their domestic purposes. They don't have excess supplies to be able to replace that in the U.S. market.
If not these countries, where else might we seek importation?
Again, of elemental chlorine, you would not see imports. You would see an increase in imports of chlorine derivatives, and those could come from any country. China has ramped up, China among others, has ramped up production of those products.
Well, thank you. This is a tough committee to be on. We're trying to balance public health, and we get it right every now and then. Sometimes we don't, and sometimes in litigation and lawsuits like this issue took the work and unraveled it again. I would encourage those following this hearing to try to get this out of our commercial use and the industries that are part of the ACC, which I'm a pretty good fan of, as everyone knows. That they look for other opportunities that would make our lives a lot easier. And Emily, you have a very brave mom, and thank you for your service too.
The gentleman yields it back. I believe Dr. Monforton wanted to respond to something she had heard.
Yes, Ranking Member Shimkus, I really appreciate you saying that we really want to get it out, and maybe we can figure out what the economic impact would be and what the timeline would be, but I think that really not having asbestos imported to our country is very, very important. With respect to asbestos in the chlor-alkali industry being handled safely, I think we have to think about where the asbestos come from. It's coming from Brazil, coming from Russia. We should have no confidence that the workers that are mining and milling and processing and shipping are being protected from asbestos. And U.S. companies have a responsibility that if they're going to be importing a potent carcinogen, they can't just dismiss those exposures. And then in addition, one can set up all kinds of policies and procedures to try to ensure that the asbestos, doesn't, the bags don't break, or when you're inserting it into the closed system. But there are so many opportunities for the exposures to occur. And on the hierarchy of controls, the very best way to protect health is to eliminate the exposure.
Thank you so much. We now recognize the gentleman from Missouri, Mr. Long, for 5 minutes, please.
Thank you, Mr. Chairman. Ms. Monforton, is it? You don't have to answer this if you don't want to, but you said that you had a cancer. Can you share what type that was? And like I said, if you don't want to, that's...
No, I'm happy to. I had stage 4 breast cancer.
Okay.
And I have no risk factors in my family. Very healthy. I don't have any, I'm not overweight. I exercise, all the only things they can tell us to do to prevent cancer, but nothing about exposure. And when we have exposure to carcinogens and we know what they do to people, that is an ease. That should be the low-hanging fruit for us.
Right, right. Cancer is near and dear to my heart, and our youngest daughter had lymphoma, and she's fully recovered 5 years later here after all the chemo and everything. And I do a lot of work with St. Jude Children's Research Hospital, so
excellent.
I just always, a little curious as to, what types and what's causing what. So we had an earlier meeting today with Francis Collins of NIH, and that's like, sitting down with the man.
Brilliant.
So,
yeah,
yeah,
brilliant.
yeah. So, but anyway, thank you. Mr. Walls, Mr. Shimkus was asking you kind of a line of question I was interested in. I mean, it used to be illegal to import LNG, to export LNG, liquefied natural gas, out of this country. There was a law against it. We couldn't do it. This committee fixed that a couple of years ago. We are able to export. You say we don't import chlorine. Is there not a demand for it? If we quit manufacturing, could we not import chlorine?
We could, but because of the properties inherent in chlorine and the method of transportation, the logical export countries of origin for chlorine would be Canada and Mexico, and they don't have the capacity to meet the excess, what would then be the diminished U.S. demand.
I just got back from a trip with the Agricultural Committee to Brazil, and they didn't have the capacity to produce soybeans that China wanted. But guess what? They're ramping up. So I'm just curious if, there was a market from Canada and Mexico for chlorine.
Right.
If they would not ramp up and be able to.
I think they would attempt to, but again, I think the properties of chlorine are such that you wouldn't see elemental chlorine imported. You would see products made from chlorine being the principal subject of increased trade.
You get above my pay grade now.
We wouldn't, in other words, we wouldn't be making those products here in the United States, but they would be manufactured elsewhere and imported into the U.S.
H.R. 16, Mr. Wall, sticking with you there, H.R. 1603 requires anyone who in the 3 years prior to enactment and the 1 year after it manufactured, imported, processed, or distributed even an incidental amount of asbestos to report this to the EPA. How do you quantify an incidental amount of asbestos, and how likely is it that all entities subjected to the requirements have maintained records to show the amount of asbestos used or produced so they can accurately report it? Again, they have to go back 3 years.
Well, Mr. Long, I would assume that EPA would set a standard. I think we heard testimony from Ms. Dunn before on what the current EPA limit is. My concern would be the reach back for 3 years. I don't believe that companies or establishments across the country are keeping those records. I think it was noted earlier that even potting soil would be subject to the reporting requirements of this bill. I'm not sure that every garden shop in America has been keeping records on trace amounts of asbestos for the last 3 years and would be prepared to report it to EPA.
Okay, as far as the bill requires the report should be released to the public, are there any concerns about confidential business information or personal things being disclosed through that process?
Yes, perhaps, and it's an uncertainty raised by the drafting of the bill. The bill amends TSCA, which does contain strong confidential business information protections, and it's not clear whether those provisions would be overridden by this bill. There's a simple legal principle that the legislation later in time trumps the earlier in time statute, and so we'd have to have a better understanding of what the intention and impact would be.
Okay, and I just want to thank all of you individually for being here today and testifying, and Emily, and it's, things like this are just hard to deal with, and anytime someone loses their life to whatever it is that was preventable is, not acceptable. I yield back.
I'd like to recognize myself for 5 minutes. And I want to focus on Section 3 of the bill because I think it's so important. We heard from EPA on the first panel that they are focusing their attention on ongoing uses of asbestos and excluding so-called legacy asbestos from their consideration. We should ban ongoing uses of asbestos, but we must also do more to address the toxic legacy of asbestos still installed in buildings across the country. And I'm going to start my questioning with Ms. Reindel. How are your members impacted by so-called legacy asbestos, the asbestos that is already installed?
Thank you for the question. We have a variety of members. It's on. Not just our members, and also other workers who work alongside of our members. Ranges from, I mean, it's really any workers who are working near asbestos. The Insulators Union did a report recently out of Chicago. They have an early screening, lung cancer screening detection program, and they reported that about 50% of workers who started work in 1980s or later are showing up with asbestos-related pleural disease. These members are, they're the ones putting up insulation, working near existing insulation. So even though the products used now might not have asbestos in them, they're working near asbestos that's deteriorating, that's getting wet, that's falling apart, that's crumbling, it's falling on plant floors. You're seeing this in schools. You're seeing this in demolition of buildings. There have been reports from some of our teachers' unions that in schools, buffing and polishing asbestos-containing floors disrupts asbestos. Any kind of maintenance work, kids playing basketball in a gymnasium rattles it. So when you have asbestos that's 50 years old, it's going to start falling apart. The stuff doesn't last forever, and it's exposing a lot of workers.
And, under Section 3, EPA would have 18 months to prepare and submit a congressional report addressing the presence of asbestos in residential, commercial, industrial, public, and school buildings, along with an assessment of the human health risks from that asbestos. How would this report help your members?
Yeah, this report is necessary. There's been no profile of where asbestos is and its condition since the 80s. We don't know. We know what asbestos does to people, and we know how people are being exposed roughly, but we don't know where it is in order to do anything about it. We need a complete assessment and in order to actually address the problem, in order to assess the risks and develop recommendations as to what we can actually do about that. And those recommendations could include a variety of things, but that's something that the report would have to come out with.
And Ms. Feinstein, first, I send my heart to you. I also lost my husband, and I know coming to Congress has given me my joy and my purpose back, so I thank you for what you're doing for the American people. And maybe you could spend a moment talking about just the impact on families and on your husband.
I'm sorry for your loss, too. Okay. When I speak for myself, I really speak for the hundreds of thousands of others. For those of us who have cared for or buried a loved one, it's immeasurable pain. We look at calendars, we look at empty chairs, we look at father-daughter dances, and those have changed forever. And I feel that 15 years of my work in Congress, we have made significant progress. You should be so proud. This is the first legislative ban asbestos hearing I've ever attended in the House. Wow. And I think it fuels our fight, like your member from Missouri said, but most importantly, I guarantee you, there are people around the world watching this hearing today and applauding you as House members for moving this forward. So there's no rewind button, but we can go forward together. And I hope it's a bipartisan movement forward. We need that desperately.
Yes. Thank you so much for sharing that. Thank you so much. And I'm going to close with a question to Dr. Monforton about just the public health aspect of this and the impact.
So the key principle of public health is protecting people's health, and having information about what those exposures are and knowing how to prevent them is what our work is about, and really saving lives.
Thank you so much. And now I would like to thank all of our witnesses for joining us at today's historic hearing. I remind members that pursuant to committee rules, they have 10 business days to submit additional questions for the record to be answered by our witnesses. I ask each witness to respond promptly to any such questions that you may receive, and at this time, the subcommittee. And at this time, I request unanimous consent to enter the following document into the record. All right. These are the following documents. A statement of support from Representative Bonamici, one of the lead sponsors of H.R. 1603. A letter of support from the International Association of Firefighters. A New York Times article published this morning titled, quote, EPA leaders disregard agency's experts in issuing asbestos rule memos show. A New York Times article published in August 2018 titled EPA staff objected to agency's new rules on asbestos use, internal emails show. A letter from the National Association of Home Builders, a letter from the Chlorine Institute, a letter from the American Alliance for Innovation, a letter from the National Rural Water Association, a letter from the National Demolition Association, a letter from the American Water Works Association. Without objection? So ordered. And now, okay. And let's see. And at this time, the subcommittee is adjourned.
Well done.
We did.
Wonderful job, Linda. Said wonderful job. Nice to meet you.
Nice to meet you.
Yes.
Linda?
I know, Mike. Let's do a sit down. You guys can do it. You know you can because other countries do. We both know that. So let's, if you came to the table.
No, you're, we can always.
We should. We owe it to people in your board members and trade associations. Nobody can beat Linda with her on the call. Work something out, right? Linda, she just. This is like a movie theater? No, she's like the AP.
Everybody contributes. Rounds out the conversation.
Yeah.
Good job. Good.
Owen is the woman in the dress.
Yes.
Yep.
Yep.